afternoon to everyone. So this is, I'm sure everyone has read already the law, the Corporate Recovery and Tax Incentives for Enterprises Act, or CREATE. And so that was signed by the President on March 26th of this year. And it took effect when it was published on April 11th. And then the implementing rules and regulations was issued by the Secretary of Trade and the Secretary of Finance on June 26. It took effect upon its publication on June 26, 2021. So our presentation will basically cover the scope, the incentives, and then the Strategic Investment Priority Plan, or the SIPP, which will be extensively discussed by Director Sandy later. And then overview as well on our registration process, the incentives availment process, and of course the monitoring of the compliance of our registered business enterprises and transitory provision. For the scope, so CREATE covers all investment promotion agencies. So all the incentives, provisions of our existing laws administered by different IPAs were repealed by CREATE. So it provided for, excuse me, it provided for a one menu of incentives for qualified projects. So the IPAs will maintain their functions. They will continue to do the registration and administer and monitor those their locators and their registered enterprises. So except to the extent modified by trade, which I will discuss in a little while. And the BOI will shall formulate the Strategic Investment Priority Plan, or the SIPP. So CREATE, later we will have a look. We will take a look at the incentives regime for qualified projects, and then so registration of projects or activities. So this is already under the IRR. It was specified in the IRR. Regardless of the amount of investment of capital investment would be with the investment promotion agencies. While the approval or disapproval of incentives would already be for projects with investment capital of 1 billion and below, it will be with the investment promotion agencies. And for those with investment capital of more than 1 billion, would have to be approved by the Fiscal Incentives Review Board, which is chaired by the Secretary of Finance and co-chaired by the Secretary of Trade. So you look at the changes from our previous regime. So registration would entail the investment promotion agencies to look at the qualifications of a particular activity in the SIPP. And then when it comes to incentives, so once it's qualified, if for projects with investment capital of more than 1 billion, the IPA concerned should make a recommendation to the Fiscal Incentives Review Board, or the FIRB, and the FIRB will take action on the incentives part. So in this slide, you will see the enumeration or the menu of incentives. So we have the income tax holiday, the 5% special corporate income tax, or SCIT, which is based on the gross income earned, and that's in lieu of all national and local taxes. Enhanced deductions. On the blue side of the screen, you will also see the enumeration of what are these additional deductions, or we call enhanced deductions. And then the duty exemption and importation of capital equipment, raw materials, spare parts, or accessories. And then the VAT exemption and importation and VAT zero rating on local purchases. I'm sure later there will be some questions on this part. Also, CREATE provides for the industry tiers, which I skip in this presentation. That will be also covered by Director Sandy in her presentation, as it basically will be addressed in the SIPP. So and then also the distinction between the incentives available for export enterprises and domestic. So generally, export enterprises could be entitled to up to 17 years of income tax-based incentives under CREATE. So that's 4 to 7 years of ITH, depending on the location and the industry tier, and then 10 years uh, of the 5% SEIT or enhanced deductions at the option of the exporter. And then for the domestic, could be entitled to up to 12 years of incentives, so 4 to 7 years of ITH, and then 5 years of enhanced deduction. So that's the difference. And that will be extensively discussed later by Director Santi. So as earlier stated, the BOI, in coordination with the FIRB, the other investment promotion agencies, other government agencies administering tax incentives, and the private sector shall formulate and recommend the SIPP for the approval of the President. So the CREATE was passed in April of this year, and in order during the transition, in order for us to continue our work, the FIRB. So as I've stated, the FIRB adopted a resolution um, making the IPP or the 2020 IPP signed by the President in November last year as the transitional SIPP, pending the issuance of the new SIPP, which is the work again of Director Sandy. So under the FIRB resolution, the registration will be initially granted with will be registered under Tier 1 without prejudice to upgrading if it qualifies under the new SIPP. And then, of course, the power of the FIRB to approve or disapprove the incentives for projects with investment capital of more than 1 billion. Okay, just generally, since we have to look at the registration. So under the 2020 IPP, it also includes export activities, which cover production and manufacture of export products, services, exports, and activities in support of exporters. So very quickly, we can just go through it. Generally, ayan. Okay. So production and manufacture of export products. So that would cover production, manufacture of non-traditional export products. And the export requirement, as stated in the 2020 IPP, is 50% for Filipino-owned and 70% for foreign-owned. But notably, CREATE provides for a 70% export requirement, regardless whether it's Filipino or foreign-owned. So we will follow that. And then services export. So this covers service activities rendered to clients abroad and paid for in foreign currency. Modern voice servers using omnichannel deliver and non-voice business processing operations. So again, there's a notation there that the export requirement under CREATE is 70% for exporters. And then activities in support of exporters. So we have this enumeration as well under the 2020 IPP. So again, I think in the previous IPPs we've done very extensive presentation as well on how our activities or our projects or our businesses should qualify under the 2020 IPP. So our purpose here is just to inform that while the SIPP is yet to be issued, we have the 2020 IPP to refer to in terms of qualifying projects for registration for the incentives under CREATE. So in this slide, I am not sure if you can really read the notations there, but basically, this is the flow chart for applications for registration. So because we noted the changes in the administration of incentives, so people are asking where do they submit their applications? Is it with the BOI, with PESA, or with the FIRB? So Basically, all applications for registration should be submitted to the the IPA concerned. So if it's outside the zones, you go to the BOI and submit your application. So the BOI or the IPA concerned will evaluate the application for registration vis-a-vis the governing IPP. So for this year until the SIPP is issued, it's the 2020 IPP. Once it qualifies under the IPP or the SIPP, the BOI will make a decision. If it's 1 billion and below, then the board approves or disapproves it, and then informs the business enterprise or the applicant. If it's more than 1 billion, then the BOI board will make a decision on the registration, whether it complied with the IPP, and then it will make a recommendation as to what incentives should be given, and then it will be tackled by the FIRB. Here, there is the submission of the IPA concerned will go to the FIRB secretariat that will also review and evaluate the recommendation of the IPA concerned, and then the FIRB secretariat prepares its report and then submits it to the FIRB technical committee. So the technical committee is also shared by the DOF undersecretary, and then the technical committee may adopt or reject the secretariat's recommendation, and then present it to the FIRB board. Once the FIRB board has made the decision, the same will be transmitted to the IPA concerned, and the IPA concerned will accordingly inform the business enterprise of the decision of the board of the IPA concerned on the registration, and the decision of the FIRB on the tax incentives. I hope that's clear. But of course, as earlier stated, this will be also circulated, so you can take a closer look at the flow chart. And generally, the processes is governed by the periods under the EODB. For example, the availment holiday, for example, during the first 4 to 7 years of operation, the availment would be first the income tax holiday, the ITH. So the firm is going to apply for the issuance of the SETI. We call it SETI now. Before, with the BOI, we call it the COE, the Certificate of ITH Entitlement. But here it's being called Certificate of Entitlement to Tax Incentives. File for such. The IPA concerned will check your compliance. If it's compliant, then the SETI will be issued, and then the firm will go to the BIR and attach the same to its ITR upon its filing. In which case, even if the project is already more than 1 billion and which has been approved by the FIRB, the IPA concerned need not go back to the FIRB for the approval of the incentive on an annual basis. So it will just be the IPA that has the task to look at the compliance of the registered project, and then if it's compliant, then it will have to issue the SETI, and there's no need to go back to the FIRB. Okay, hold on. Okay, so here, these are the compliance requirements. So once the project is registered, there are terms and conditions that everyone should be very aware of. And so the conditions for availment of incentives is, of course, the fulfillment of these requirements, those that are under the SIPP, and those that are the target performance metrics that will be specified under the terms and conditions of the registration. Generally, this would include your commitment to start commercial operations at a particular date, your commitment to put in the investment capital that you have represented, and the employment that you have committed on an annual basis will have to be checked. So generally, these are some of the target performance metrics that each registered enterprise has to be very conscious about, so that there will be no issue in your availment. Okay, and then these are under the create, so compliance with the e-receipt and e-sales requirement, installation of an adequate accounting system, submission of annual reports, of course, and submission of the annual tax incentives report and annual benefits report, and then so on incentives application, etc. System to ensure that our applicants are not burdened. No, we try to simplify also the forms. So we are working on that, especially that we are in under the election session. So stop. Okay, so just to highlight, under the create IRR, there is their provision on temporary measures for exceptional circumstances. So the exceptional circumstances are enumerated therein. So that would include pandemic, like what we have now, the COVID-19, etc. This will basically give our enterprises and support during these exceptional circumstances, like if their profits are affected during the this exceptional under this exceptional circumstances. So there could be a suspension of the export requirement that shouldn't affect also their availment of incentives, deferment of the ITH availment period. So in which case, the firm is able to preserve the enjoyment of its ITH incentive at a later time when the situation is already okay and they're able to utilize or maximize the business, and then a movement of the start of commercial operations, because in the old regime, once you committed to start at a particular date and you're not able to do that, then it already affects your ITH, so nababawasan your enjoyment of the ITH, in other words. But with the movement, you're able to also preserve your ITH entitlement period. And then adoption of any other measure. But then this is subject to the FIRB approval. So this is one very good provision under the create IRR. Will continue to avail based on their existing terms and conditions. Those that are still entitled to the capital equipment incentive, which is 5 years from their date of registration, they should be able to enjoy that. And then those under the 5% GIA regime, so that's 10 years of the 5%. 10 years they should be able to continue to enjoy the 5% GI. I hope that there will be no questions on the transitory provisions. So these are provisions of the law. I think we have passed already with the discussion on why there is a need to stop, etc. The incentive. So I think that's the last slide. So thank you very much.